Hello, everyone. Welcome to Save News TV. I am your host, AZ Hubbard, and I'd like to thank you so much for inviting me into your homes because you know you did not have to. But anyway, today we are following up on the TD Jakes versus Duane Youngblood case. This is the transcript of Tyrone Blackburn at the show calls sanction hearing. Now, I have to be totally honest with you all. I have had this for a couple of days, but reading all this stuff, it takes time. And sometimes, honestly, it's sort of tiring and you have to be in the mood to read, and most of the time I am, but this time I was not. But I appreciate you being patient with me. We will go over this. I will do commentary in this. As you know, we do not have a dog in this fight on this TD Jakes versus Duane Youngblood case. We are just reading and commenting based on what has been said. And I know some of you are Team TD Jakes, some of you are Team Duane Youngblood, and some of you are now Team Tyrone Blackburn. But whatever team you on, just be respectful in the comment section. Thank you. But anyway, make sure please like, share, and subscribe. So and share, so other people can get this information. So without further ado, let's get into it. Okay, so this is pretty juicy, and this is the transcript that was going on in court. And so let's get into it. Who was in appearance? The attorneys and Tyrone Blackburn. Also, a special appearance by TD Jakes. So let's see what happened, everybody. The court. We are here today on record for the sanction hearings pursuant to the court's order docket number 53, issued on June 26, 2025. Would counsel please enter their appearances? Counsel for the plaintiff, Mr. Janey. For the plaintiff, Thomas Dexter Jakes, the Janey Law Firm by Darrell Janey. Good afternoon, Your Honor. The court. Good afternoon, Mr. Janey. And with the court's permission, I'd like to point out that Mr. Jakes is here in the courtroom gallery, Your Honor. The court. Okay. Good afternoon. Mr. Polch, Dustin Polch, on behalf of the plaintiff from the law firm Meyer Watkins Phillips Polch. I'm joined by my colleagues, Amy McCain Roller and Casey Christian as well. The court. Good afternoon. Mr. Chawastik. Good afternoon, Your Honor. Devin Chawastik of McNeese, Wallace, and Newark, also for the plaintiff, the court. Mr. Blackburn, I presume. Mr. Blackburn, yes, Your Honor. Now, pause. One thing we notice here, there's a lot of attorneys here on behalf of TD Jakes. Okay. Now they're looking to get reimbursed for the filings that Blackburn made. And with all these attorneys up in the courtroom, this is a lot of time and money that's being spent that will be attributed to, possibly if sanctions are imposed, um to Tyrone Blackburn. Okay. So also remember, if you don't know, if you're not up to date with what's happening, down in the comment section, there would be a description of, the playlist, so you can get caught up. You can click on the playlist in the comment section. So let's get into it. The court. Okay, so Rule 11 hearing, especially one that's ordered sui spate by the court, is a somewhat unusual proceeding in that it's one that, whereas the court is normally an umpire between the parties, the court, by necessity, has to take the lead in examining the evidence and creating the record with respect to whether there was a violation of the rule, and if there was a violation of the rule, the appropriate sanctions to impose. In this case, the court issued its order on June 26, ordering Mr. Blackburn to show cause why sanctions should not be imposed as a result of his authoring and filing briefs and submissions before the court that contain what the court believed to be, and I believe has been confirmed at least in part by the Blackburn subsequent filing, artificial intelligence hallucinations. There goes that word again, hallucinations, which, amongst other things, miscited case law, including this court's own previous filings in this case. I issued that order, and that order required Mr. Blackburn to come to court. The order invited the plaintiff's attorney to come to court only to the extent that they were seeking attorney fees as part of this proceedings. So, Mr. Blackburn, you are the subject of today's hearing. For the record, sir, are you representing yourself or do you have counsel with you today? Mr. Blackburn, I'm here alone. So, uh, we see that TD Jakes' attorneys are in the courthouse. They in the house. They are in the house because they wants their money. They wants their money, and they are in the house. And not only are they up in the house, TD Jakes are up in the house saying, "Hey, I wants the money to for these bogus filings. That's artificial intelligence, okay, hallucinations." Oh, so let's get it back to it. The court. Okay, then the next question that I have for you is, do you have any witnesses or documentary evidence that you intend to present to the court today? Mr. Blackburn, aside of what I provided on the docket, I have nothing else unless I didn't want to give the full research history. It was a lot of cases. I just gave like a small sampling of the cases that I researched for this motion. So it so if the court wants, I can supplement that with an Excel spreadsheet of the cases and their relevance. I didn't think the court would want and the judge cut them off. Are you referring to the document that you already filed in support of your submission at ECF number 57 and its exhibits? Now, the judge just cut him off mid sentence. Mid sentence. Tyrone Blackburn is in a lot of trouble. And, he's just really, it sounds like he's throwing himself on the mercy of the court. Mr. Blackburn, yes, that's more than that. There's more than that. I did not want to inundate you with so much documents. There's more. I actually have additional samples I can show you. My metadata from my devices to show that there were researched on the dates and time that I said that I they were researched. So I have sample motions as well as additional case law and additional search history. So just so the court is aware, when I have a lot of cases, and like I said in my papers, that I represent a lot of people for free because they just can't afford to pay. So on the day that I wrote this, I typically go to bed like 2 o'clock in the morning and I wake up at 6 and the judge interrupts him again. He's like, oh, listen now. Look, we're not going to go through all this, okay? The judge stops him. He says, Judge Stigman, he says, I'm going to stop you right there. Just so that procedurally we're all on the same page as to how we'll proceed. The next question I'm going to ask is whether there is anything that you would like to testify to today to supplement or to elucidate any of the writings that you already provided to me. I take it from what you're already begun to say that the answer is yes. Am I correct? Blackburn says, of course. So in other words, the judge is like, I don't want all this talking unnecessary about when you go to bed, when you wake up, and all this other unnecessary stuff. Let's just get to the point. So then the judge says, okay, raise your right hand to be sworn in. And then they give the administrative oath. The judge Stickman says, okay, so you may proceed and offer to the court any additional testimony you would like on the record to reflect for me to consider when determining whether sanctions are appropriate. In addition, when you're complete with your testimony, I'll extend on asking some questions, not only about anything that you might come to my mind during the course of this testimony, but also some of your submissions you have already get specifically in your declaration ECF 57-1. And he says, okay. So the judge is definitely on it. He is not wasting any time. He is like, we're going to get down to this and we're going to get through this quickly. Okay, so the court says, you may proceed, sir. And then Blackburn says, thank you. So, as I was just sharing, typically, my days run long because of the amount of work I have. But for this particular motion, I think the night before I went to bed like 1 or 2 in the morning, and I woke up at 6 and I began doing the research and beginning to outline my motion to dismiss. The court again interrupts and asks a question. But with this particular motion, when you refer to the motion, you're referring to the motion to dismiss that you filed on May 5th? Blackburn says, yes, Your Honor. Yes, it is, Your Honor. The judge says, okay. Blackburn says, so I typically do all my research. I typically outline whatever the motion is or the document. And then I do the research for the law cases. And then I put it all together. I try to find matching things that make sense. So I never use this Lexus AI thing. Before I had regular Lexus, which required me just, independent use, search terms, and all the stuff. But this thing is completely different than what I'm accustomed to. And when I had the ability to upgrade, this is what was sold to me. Not upgrade, but a renewed my contract. This is what was pitched to me. I've been a Lexus rep since I was in law school back in 2010 until then. And I've been using them from then until now. So I didn't think there were any issues with them on how it was sold to me. But again, not making any excuses, I take full responsibility for not reviewing and really cross checking what was spit out of the program until I had uploaded the case that I thought was relevant. I uploaded the court's opinion and I also uploaded relevant facts of this, pertaining to this case. You know, what I should have done was probably just recall the first motion that I had filed and just restructured it. But I didn't do that for some, I don't know why I didn't do that, but I didn't do that because I thought, you know, got this new thing, should just use it because it was pitched to me. So, it's pretty much that's pretty much it. I just made a mistake. I just really don't have any other explanations for that. Well, we really understand, take a break on that irrespective of what the software kicks out, it is up to you as the attorney, because you're signing an affidavit that this is true, and you are a member of the court, that it's your responsibility at the end of the day, whether what comes out of it, regardless of how it got there, whether it was Lexus AI, LexisNexis, a paralegal, or whomever. At the end of the day, as the attorney of record, they are responsible for that. But I do have to say here that there has been other cases where there has been even a judge this past week that has been caught using AI, and there was in his judgments, in his ruling on a case. So this seems to be more of a reoccurring thing that people are thinking, they're going to depend on AI for these things. But anyway, let's get back to the case. All right. The court says, I appreciate that you're taking responsibility for acknowledging that the May 5th brief was created by Lexis AI tool. Blackburn said, the protege. The court says, what's that? Blackburn, the protege is called protege. The court protege. Ooh, okay, protege. Mr. Blackburn. And before I wish I had known this, but before I agreed to the upgrade my subscription, I should have done more research on it. You think? You think, you know, these things have major consequences. So I think you should have. He says, I didn't realize it had a lot of issues, and subsequent to having these issues come about, I've done a lot of research, and I've learned that there was a study done by Professor Benjamin Perrin, who said that it's riddled with mistakes and should not be used in any form. And then on Reddit, there's a bunch of complaints. There's an F rating on the Better Business Bureau. So I just didn't know. I should have done my research. I should have done a lot more due diligence before accepting this, upgrading, utilizing it in any work that I do. Wow. Okay. So that is crazy work there. Right. Do you have a paralegal in your, and Blackburn cuts him off. I have nothing. I mean, the thing is, Your Honor, a lot of people that I represent cannot afford to pay. He says, they cannot afford to file their own case. So what I do is I do the work for them. And if they get anything back, I just take that from my out of pocket expense, such as attorney fees, not fees, but court fees. Which one is it? Is it both? Attorney fees, not fees, but court fees? The expense for depositions and even experts. And I take that back, and then I let them keep whatever they have, because a lot of them are disabled because of medical malpractice issues, or they have issues regarding loss of, loss of their employment because of age or disability. So there's a lot of different things that these individuals suffer from. The court, I appreciate that. And in this court, we have a number of lawyers that represent public interest or pro bono cases. But the problem is this case is that Rule 11 is a non-deligible duty. So in other words, Judge said, I appreciate you being you know, very philanthropist and doing pro bono and all of those good things, but that has nothing to do with this case and why we're here today. Blackburn says, of course, the court says, I asked if you had interns or secretaries because, by way of example, if you had an intern and you had an intern, you gave the intern a stack of facts and the briefs, and you said to the intern, draft a brief for me, and then you filed the brief under your signature. Blackburn cut him off because he already knew what was coming. Blackburn said, still my responsibility. Yes, Blackburn, it's your responsibility. That's what the court said. It's still your responsibility. And it doesn't make a difference if it's a product sold by a computer company that says they can write your briefs or not. It's Mr. Blackburn and Mr. Blackburn alone who is representing to this court that the representations are accurate and truthful. So, in other words, Judge said, while all that's admirable, at the end of the day, it's all on you, dude. It's all on you. Judge continue. And I guess some of the questions I have, and I'm going to move in my questions from your declaration before the court, is at paragraph 3, for example, of your declaration. You state that you received a safe harbor letter from the plaintiff's counsel, which you attached as an exhibit to your declaration on June 17th, 2025, and that you immediately then began reviewing and revising the memorandum of the law. And the question, are you referring to the May 5th memorandum of the law? Blackburn, yes, but Your Honor, before I had already highlighted in my reply that I acknowledge that I acknowledge the errors, and in my affidavit I have outlined what was supposed to be corrected citation. So that's what I was referring to. But when I got the letter, I spoke with my client, well, my former client, and I explained to him what it was. And I explained to him that I had a duty to make the corrections and to correct the record, and that I was in the process of doing that. The court. And this was after the June 17th letter, Mr. Blackburn. Yes, but before that, during the, during the motion period, I had already like highlighted everything that I needed to make corrected. And I was very slow at it. Excuse me. At actually making them and uploading them. And then I got this June 17th letter, and I just put my focus on that, and just to explain what was happening, because I think context is important. I have about 7 clients who filed suit against Sean Combs, and several of them were witnesses in the criminal case in the Southern District of New York. So a lot of my time was spent there with the prosecutors, prepping them and preparing them for testimony. So that is kind of what delayed me in having the time to immediately submit. The judge just cut him off. Boom. think the context is important. And you raised the issue of context. So I'm going to stop pause right here. So it's just like in any court case. If you if the judge has if an issue has not been raised, it can't be raised unless someone voluntarily brings in that information. And Blackburn, context was not brought in by TD Jakes' team. Context was brought in by Blackburn, and he just threw a noose around himself and tied himself up when he mentioned the word context. So that opened the door for the judge to continue to go down a new route of questioning. So let's see where this goes. Now, the question I have though is the question that I have is the accuracy of your declaration about the June 17th date, when in fact on May 27th, the plaintiff's opposition had already indicated and made the accusation that the May 5th brief it contained artificial intelligence hallucinations, including misrepresentations of my own opinion. Is that right? Blackburn. Yes, 100%. Like I was saying, just to touch on that, I had already highlighted found cases, and also highlighted and went through the sections that were inaccurate quotations, and I responded in my reply brief with that. And I was in the process of fixing that and correcting. I should have done it faster. I should have done it sooner. I should have made it a priority. But like I said before, the judge cuts me off again. He would go down this road. Okay. The court says, Judge Stickman says, you raised the issue of your reply brief. So again, uh, Blackburn is doing himself no favors. He should have brought him some counsel in to represent him in this. He keeps raising and opening the door for the judge to ask additional questions that was not even brought up by the plaintiff, T.D. Jakes, um, in this. So Blackburn is pretty much the detriment of his own case. Okay. So by my review of the record in this case, the first accusation that the May 5th brief was filed with misleading and misstated or non-existent quotes from cases was made. We immediately noticed the unusual non-quotations from my own opinion. They put on the record as of May 27th the issue of artificial intelligence. I received your reply on June 2nd, and the June 2nd brief, rather than striking or acknowledging mistakes that were made on the May 5th brief and withdrawing it, my characterization of the June 2nd brief is that it doubled down, and that your review of the June 2nd brief, independent of anything that we have received from them, was that the citations in that brief were questionable, non existent, misleading, as the quotations of the first brief. So, although your declaration at the ECF 57 paragraph 3 indicates that you were made aware of AI issues by opposing counsel on June 17th. The plain record of this case demonstrates that the accusation was made on May the 27th, and that your immediate follow up to that on June 2nd was to double down on the AI and accuse the other side of using AI rather than taking responsibility at that time. So now, boom, he's busted. Busted lying to the court. I mean, Blackburn is already in enough trouble. Why lie to the court? You know, like they don't have a memory of what, like the judge wasn't there. Like the judge doesn't know these things. I'm not getting it. Okay, Blackburn, look, Your Honor, I believe that I took responsibility in my affidavit where I acknowledged that there were errors that I filed as part of my reply brief on the June 2nd. So I just feel my reply. I've just filed my reply. I just filed my reply. I should have struck the issue. You see how he's fumbling over his words. Sound like he's trying to figure out what story he's going to tell, what untruth. Trying to weasel his way out of it. But man, you know, just fall on the sword and just tell the truth. That would be the best thing. Now he's falling on the sword, but he's caught in not being totally truthful with these things. He continues. But I thought that the correct course would have been was to just make the changes, the corrections in the actual documents and file them. But I did acknowledge that they were wrong and that they were inaccurate. The court, you acknowledged in your declaration, Blackburn. In my declaration, yes, the court. But the first opportunity you had to make that acknowledgement, Blackburn cut him off. No, no, no. I think I filed a declaration in my reply as well. If I'm not mistaken, I think I did. The court. The reply brief, as stated, Blackburn cut. Look, he knows he has told an untruth. The judge is finding him out, and he's trying to weasel his way out of this. Blackburn. No, I think I did. And then I added, I think I may have. I know added attachments as well. The court, beginning at page 5 of my order on June the 26th, it highlights a representative series, not exclusive, but the representative series of misstatements of case law from the reply brief, which was filed on June 2nd. One of the questions I have about that also goes to your explanation as to how the AI tool, based on your misunderstanding, works, in that you would be able to put quotes around what you believe were parentheses. Tell me, does Jackson versus Lehigh Valley Hospital, the case cited to me from the Circuit, does it exist? Just saying, is this really a case? Blackburn. No. So what happened was, Your Honor, was that was what ended up happening is that there were some mismatches of, so like it would take one title and like attach a citation. That's what I discovered through all of this. It is, that's an error that occurred. So it would take one title or one section from the case that's probably, it would take a case title and it will attach a citation at the end that's not accurate. That's essentially what happened. And again, I have no explanation for why I did not catch that before I filed. So the Judge Stickman said, so it wasn't actually then merely putting quotations around the artificial intelligence summary in your cases. Blackburn. No, no. So I uploaded the actual, I uploaded your order. I put a little summary of what the issues were, and then I did, hold on. I wrote out the fact sheet of what I want the body of the memorandum. Then I submitted that as well as a brief history of what the issues in the case are. The issues are in the case. Then I selected the jurisdiction, and there's a function that allow you to upload documents, and that's what I did. I uploaded documents and different things from the court that the question was, and then a part of the uploads were actual cases that downloaded from Lexis tool, as well as some cases that I downloaded from Westlaw. And I have the cases here. I did the research. I wasn't trying to, like say, I was not trying to defraud the court or anything like that. I highlighted in a lot of the documents that I selected sections that I wanted. And then I uploaded that into the system, and then it generated what it generated, and it was inaccurate. Woo! And I should have caught it. And the court judge says, listen, the question I have though is, even with crediting that explanation, how did that lead to the citation to a case which simply doesn't exist? Neither in name nor citation, nor in a quotation that is attributed to it. The judge is saying, dude, this isn't adding up. You got a whole case in here that does not exist, not in name, not in citation, nor in quotation. Now, how does that happen? Just a whole made up case. Blackburn, of course. So again, the issue is that it created this. It created a citation. I don't know how. I don't know why. But it just picked a name and it picked a thing and just put it together and gave a quote. Poof. Magic. It's just like, woo, buddy. Again, I should have caught it. Um, I made a huge error on this, and I should have understood this program a lot better and not used it. Actually, in doing this, and it's a mistake. The court. Moving on to the declaration that you submitted to this court on the 19th, just last week, you stated to me that you practiced law since 2018. A quote, and during that time, I have never encountered citation or quotation issues in any legal filing submitted to the court. And this is the first instance of any this kind in my professional career. I've always respected the significance, excuse me, of Rule 11 and the duty it imposes on attorneys to ensure its accuracy, factual foundation, and legal grounding of each filing. You mentioned already today the Combs case that you're a part of. Now, Blackburn says yes. He says, in the Combs case, is it not the case that the judge, Blackburn, Oaken, yes, Oaken, the court said, in the Southern District of New York, cited you for, quote, Blackburn's filing are repellent with inaccurate statements of law. Is that not the case? See, now that's what I'm saying. Like I said, we don't have a dog in this fight, but Blackburn is constantly lying to the court. It's like that he think that the court is not going to do their due diligence for a matter of this seriousness. I mean, I just don't get it. Oaken, the court, Oaken of the Southern District of New York, cited for you for, quote, Blackburn's filings are repellent with inaccurate statements of law. Is this is that not the case? Blackburn. Well, so I'll tell you what happened there. Again, I think context matters. So when I filed the opposition to the defendant's motion to dismiss, Sean Combs had just been indicted. And in my opposition, I said, I think I concluded that the indictment with him being guilty, and that was Judge Oaken, I believe, was referring to or getting upset about. But prior to that, again, I think, you know, context matters, especially on that case. There was a lot of, it was an extremely contentious time frame in that a lot of things happened in that case leading up to that filing, right? So my devices were hacked and I had to file a report with the federal government. Okay, so now not only did he, use AI, but now he's saying that his devices were hacked. Man, Blackburn just seemed to be having a lot of issues. Okay. All my files were wiped out in my case. My client's 7-year-old daughter was approached by some private investigator at her school and was being harassed. I had people following me, following my client. So there was a lot of things happening during that time that led up to that motion. Well, me feeling filing that position, I was extremely angry when I filed it. And I said that, he was indicted. So therefore, he said, I guess the sum of it was that he was indicted. So therefore, there's no need to dismiss any of the claims because the same claims that we had in our civil case were the claims that he was indicted on in the federal case. Okay, Blackburn. The court. So Judge Coates on April 3rd, 2024, and again, I'm questioning the statement you've made in paragraph 2 of your declaration, ECF 57, states that Blackburn's actions in this and prior cases indicate a repeated failure to meet his Rule 11 obligations. And in that case, Judge Coate referred you to the court's grievance committee. And again, that was April 3rd, 2024. Is that correct? Blackburn. Yes, 100%. The court. And that was the as of March of this year, Judge Oaken notes in his opinion that you had proceeding pending against you in the court's grievance committee. Blackburn. Well, I'll tell you this. I've never been contacted by the court's grievance committee for the Southern District of New York. And Judge Coates' opinion was based on jurisdiction of defense. So my client informed me in that case, my research showed that my aunt that the defendants, which was a law firm, two-party law firm, was domiciled in the state of New York, Manhattan. My client lives in New Jersey. So my contract was to bill $75,000 add the diversity of jurisdiction. My client's assessment was wrong. I did my research on that and came out that the plaintiff and one of the defendants lived in Manhattan, and the attorney for the defendants came on to the case files and said that, her clients lived in New Jersey. Judge Coate felt that I should have listened to the attorney's statement about where her client lived. And I said, respectfully, unless she proves to me with proof that her client lives there, I'm not going to just take her word for it. She provided proof to the court, and then Judge Coate went through all of my filings from 2019 in the Southern District of New York and, found issue with different things. And that's what created that opinion. Blackburn is in trouble. I feel that he's in trouble. That's just my personal opinion. Y'all get in the comments and tell me what you feel. The court and Judge Coate made that reference to disciplinary or grievance committee, which I presume is the disciplinary committee. Blackburn. I've not gotten a word from them, the court, but that was made in an opinion that is of the court on April 3rd, 2024, correct? Blackburn, correct. I mean, yes, the court. And you are aware of that. Blackburn, yes. The court. Okay. The reason I asked that was on April 3rd, 2024, your Pro Hoc Vice application was filed before this court on January 15th, 2025. That's at ECF number 33-1. And at page 1, section 3, you state, I have not been subject to any disciplinary actions, suspensions, or disbarment by any bar, court, or administrative agency. You omit Judge Coates' reference to disciplinary committee of the Southern District. So again, here we go. Blackburn is telling untruths to the court or omitting information. I just think that he is in some serious trouble here. You tell me what you think. Blackburn, Your Honor, I have never been, I'm letting you know, I don't know what you know, how that works, but I understand from a recent situation with, I believe, attorney Tony Busby in the same court in the Southern District of New York, where Judge, I think, is Valles, referenced him to the grievance committee. They acted right away. I've never been contacted by the grievance committee. I've called to inquire and they have no record of it. So again, when I wrote that, I wasn't lying. I've never, the state bar of New York never contacted me with any kind of grievance issue. New Jersey never contacted me with any grievance issue. And no federal court has ever contacted me with any grievance issue. The court, you just believe nothing came of Judge Coates' referral? Blackburn, huh? The court, your presumption was that nothing came from Judge Coates' referral. Blackburn, not that nothing came of it, to say that she referred me, and then I contacted the office and there was no referral. I mean, I don't know how the process works. I'm not a judge. I don't know what the process is to refer someone to a grievance. The court, moving on to your Declaration 57-1 at paragraph 12, you stated that you have voluntarily taken CLES, dealing with artificial intelligence, to help understand, including number one, the ABA class entitled, quote, AI is changing the legal profession, but not your ethical duty, unquote. What date did you take that? Blackburn, I can tell you right now, I took it on July 18th, I believe. The court last week. Judge Stigman is not playing. Blackburn, yes, Your Honor. As I was completing this and drafting this, I was looking up the AI and all the stuff. I started seeing CLEs pop up, so I decided to take them in order to gain better understanding and knowledge. So I took three, two from the ABA, one from I think is I don't remember the acronym. The court, do you have certifications of completion? Blackburn, yes, I have them. I can upload them. I can provide them to the court. And then I also have actually I took additional CLEs with New York State Bar Association, as well as I signed up for some New Jersey as well. I just, you know, I'm trying to make sure that I completely understand this thing and not get an error again. Okay, so he's landed on the court. He's landed on the court. Judge Stickman, which is the court, goes on to say, number 2, complete your CLE request and program evaluation, catching up to AI ethically. How existing ethics rules apply to artificial intelligence and how to guide lawyers in avoiding the ethical pitfalls. Who sponsored that CLE? Blackburn. That's the one whose name I'm looking up. I have a certificate though. The court. What is date was it? Blackburn, the same date. I took them all. The court, July 18th. Blackburn, yes, I took them all. Stickman, all 3 of them. Blackburn, yes, all 3 of them. The court, how long did each take? Blackburn, I believe I don't want to misquote. So I want to confirm. The court, it's only been a week. That's your Blackburn. He interrupts him. He says, I think I think like an hour and a half, 2 hours, 2 hours, and one was only 2 hours, and the other two, I believe, were an hour and a half and a half. I don't want to misquote. The court. So TRCLE, artificial intelligence and legal practice. Same answer to that. The 18th, Blackburn, yes. The court. So today, my specific questions with respect to your declaration are finished. But as you know, we are here today on an order to show cause why you should not be sanctioned. I will allow you the benefit of having the last word of that question. And the question is, if you can give me now your summation in light of your admitted failure to review your own briefs to ensure that those briefs were cited real case law with real quotations, sometimes in real cases, why should I not issue a sanction? And if I should issue a sanction, what sanction should I issue? Okay, so now, Blackburn gets a chance to plead his case for the last time before the judge make his determination on what he's going to do. Honor, like I said before, I will I take full ownership for what I did. I'm not, you know, coming here trying to, make any kind of excuses. I should have been more diligent with what I filed. You know, there's really no excuse for it. I completely understand what my Rule 11 obligations are. I was raised by Marines. So I'm not going to come in here and make an excuse for what an error on my part, which I should have been more careful for. So if the court feels that I should be sanctioned, I'll leave it up to your honor to make that decision. I will fall on the sword to take whatever the court deems appropriate in this context. Oh, he's going to fall on the sword. He's falling on the sword. He's falling on the sword. Oh, how noble, noble the court. Okay, understood. So the other question that I had today is there has been an indication that the plaintiffs as part of any sanctions, and the court will review the records as well as the case law. And there is a prevailing body of case law developing around this very issue. Before I make my determination as a threshold matter as to whether sanctions are warranted, but if sanctions are warranted, one of the things that cases have done is award attorney's fees. hmm Attorney's fees. Not for you, but for the other, like TD Jakes on this case, because you caused them to pay some extra money. In this case, the attorney's fees, in my mind, would be the reply brief, the response brief, analyzing and responding to the May 5th brief. Are you prepared today to present evidence as to the amount of the fees that your client incurred as to the analysis of May 5th brief and the response thereof? Mr. Pulch. Now, remember, it's been a little bit, but Pulch is T.D. Jakes' attorney, one of many T.D. Jakes' attorney. He goes on to say, "Thank you, Your Honor. I appreciate it. Dustin Push, on the behalf of the plaintiff, I think we would respectfully request to file evidence of the appropriate fees that we believe should be awarded. And we do request that fees be awarded." Okay. It's a funny thing. Tyrone Blackburn says he took this case pro bono. He hasn't been paid, but so he was working for free, and now he's going to end up paying the plaintiff TD Jakes. So this is crazy work. Crazy work. Well, that's if the judge rules for sanctions and require him to pay um damages to the plaintiff. Okay, Push goes on to say, "I think that certainly the work that went into from our perspective, and it was a relief to hear that the court was discovering exactly what we were discovering as well at the time as your order." The judge, "The court generally is familiar. It's one thing when I cite someone else's case. The court is generally familiar with what I wrote myself." So the judge is telling TD Jakes' attorney, "Well, it's not really amazing because I know what I wrote. So, I should know what I wrote." So Post says, "Absolutely, Your Honor." He had to correct himself on that. Don't try to get too over the cusp, okay? He says, "We expected as much. Nonetheless, of course, we've got to do our own due diligence at the same time. Certainly, the opposition brief, in which we had to spend significant time and energy to uncover exactly what was going on. Obviously, responding to a motion to dismiss is a lot of work unto itself. But there, as my declaration states, there's the incredible amount of work that goes into uncovering these type of misrepresentations that are in a brief. I will say, by the antidote of my own experience of this, was reading the quotations from the court's opinion, the supposed quotations, and personally feeling like I was going crazy, not knowing what was going on here, rereading your order again and again, figuring out what was going on. And I'll leave it at that. But I do believe, well, let me say this. Let me break it here. Even we that was reading the cases ourselves, we were wondering whether we were going crazy or not, because we knew that's not what the judge wrote. Anybody that read the judge's order knew that that was not what the judge wrote. So, we all was wondering what's going on here. Okay. So he continues, "But I do believe that we would request that the fees go beyond just the opposition brief. We were forced to file a motion to Sir reply, and Sir reply that not only called out the additional misrepresentations, but also had to defend my law firms and my co-counsel's law firms and the plaintiff himself from the false accusation that we misrepresented case law. We requested consent to file that surply. That was summarily denied by Mr. Blackburn, telling us specifically that we were not to get another bite at the apple in filing that reply. To me, that does not sound like he's in the midst of figuring out what's going on, in the midst of fixing it, especially on the heels of the reply that he filed. Moreover, the testimony by Mr. Blackburn in his declaration and today is that it wasn't until sanctions motions were served on him. We've never filed it. We served it on him in accordance to Rule 11, following all the rules despite all the knowledge of what was going on. Of course, we had to do that. That's what the rule states. we it was after that he's now claiming that he began the process of fixing something. Moreover, it was only after that we finally got any word whatsoever from anyone from the defendant's counsel about what was going on here. In my practice of law, I've never seen anything like this. He said, in all my years, I've never seen anything like this. And I expected a various different points of the process that we would hear something, anything about this. We did not. So would humbly submit that our clients' out of pocket fees for paying to uncover this and continually have to have a completely unnecessary fight about this and continue to have to submit briefings and filing after filing to finally get across to someone the issues here. Of course not to this court necessarily, because you were discovering it on your own. But to counsel, I would humbly submit that our fees should extend just beyond the opposition and go as well to the reply as well. So in other words, we want all our money for take wasting our time, not just that, you know. There was more to it than that. We spent more time on it than this. That's what TD Jakes' attorneys are saying. The court said. So to answer my question though, today you are going to elect to wait to see if and what, if so, sanctions, excuse me, this court imposes upon before submitting a reasonable fee petition with numbers. Mr. Poach, we're we welcome the opportunity to submit that before. We would submit it before, but I defer to the court's guidance. The court, do you have it today? Mr. Poach, we don't have it today. We have to put it together. We would put it together pretty quickly. The court, is there a reason you don't have it today? Because really, like the judge is being fair here, because just like he got on Blackburn, he was getting on TD Jakes' attorney. He said, look, I told you all that if you were going to be, if you want to get your fees, you need to be here today. Well, here you are today, but you don't have a quote as to how much money you want. So that's all the judge is saying, like, look, what's this? You don't have how much you want some money, but you don't know how much you want. Okay, so then the judge goes on. Let me get back to what the judge said. That was what I said. That's my commentary. But the judge says, you came in here for this hearing. You were invited to come here for this hearing to the extent that you were going to present a fee petition. Is there a reason it's not here today? See, and I like this judge. I like Judge Stigman. He's a fair and square judge. He ain't pulling no punches. He's not showing any favoritism. He tells you, listen, I told you to be here today if you wanted your fees. To put your petition in if I should rule to sanction him. And you don't even have this stuff together. What's up with this TD Jakes attorneys? Why don't you have your stuff together? Okay, Mr. Polk says, I apologize, Your Honor. So here he is apologizing. Now we got all these attorneys in court, ill prepared and apologizing to the court. I may have misunderstood. No, how can you misunderstand it? I understood it. He clearly said the judge clearly said in his ruling, um, back last week, I mean, initially, that these are the dates, and if you want your money, put in your petition on this date. You understood to be here. What's up with these excuses? Okay, he said, my understanding was to appear whether or not we were going to request it. No, no, you can't even pull that now. No, that's not what the judge said. You busy reading what Tyrone Blackburn, you said it was wrong with what he was saying. Why didn't you read what the judge said? Oh, Post goes on to say, we have invoices, we have redacted invoices that we can present to the court very quickly, and we've prepared them. I just don't have them ready to hand to you right now, but we could provide them probably by tomorrow along with the petition. If not the end of today, by the end of today, the court. Here's what we'll do. I'll give you until today. It's Thursday. I'll give you 7 days. Poach says, okay. Court says to supplement with a formal fee petition with any of the supporting information. Mr. Blackburn, I will give you 7 days thereafter to respond. Blackburn, okay. The court. And then I'm not saying that I'm going to find that that sanctions are warranted, or if sanctions are warranted, that fees are the type of sanctions warranted. But I want to have a full record before me before I ultimately make that determination. So you have 7 days, 1 week from today. Mr. Blackburn, you have a response within 7 days thereafter. And then after that time, roughly 14 days from today, you will hear from the court in a very short order a resolution to this issue. So the judge is going to do a short order. So this should be interesting. It should be short because it seems like he ain't playing with nobody. Okay, so Pope says, thank you, Your Honor. The court says, anything else, Mr. Blackburn, before we adjourn? Blackburn says, I just want to follow up and reiterate that I had already begun outlining, as I explained to the court. I think the court asked the question regarding why I had not, I guess, it was like why I had not made the changes since the opposition brief had already identified all the issues in there. I just want to reiterate to the court the circumstances that I was involved in, plus the fact that I had identified it. But again, I just didn't have the ability to move as quickly as I should have moved. I would have had wanted to move. The court says, look, I appreciate that. And I like to say that many people that sit in that chair in other contexts, I appreciate when someone comes in and takes responsibility. I do. I guess what puzzles me in this case, Mr. Blackburn, I alluded to already in my order scheduling today's hearing, is that for an attorney who takes Rule 11 and frankly his professional reputation seriously, when the other side accuses you in a brief of filing a brief repellent with nonsense to the court, including completely misquoting the presiding judge's own opinion, I think that due diligence would leave most reasonable lawyers to immediately take action to figure out what happened and resolved it. Blackburn, 100%. The court. But that's not what you did. What you did is to file a reply brief that included more AI hallucinations that made up a case that doesn't exist for the Third Circuit. And then, as they indicated, offers a tout de croix. You also defense saying to them in to saying to them, your brief is full of artificial intelligence. Well, we did a site check of their brief. Their sites and their quotations worked out. So I guess I appreciate your coming to in today and falling on the sword and owning up to what you did. I do appreciate this. My concern is, though in real time, the initial response was not to take responsibility, but it was to double down and make accusations. And that's what I struggle with, is balancing when I go back to into chambers, when the record is fully complete before me and I sit down with case law that's developing in this area. What I struggle with is balancing. And this court balances all the time multifaceted issues, balancing your acceptance of responsibility today on top of what you did in real time. And ultimately, my decision will make that balance. But I guess that's my problem, though. Is it is it continues today? As you come in here, you're taking responsibility but not making great explanations for what you did in your reply brief. Blackburn, you know, yes. So look at the brief. I mean, I'm trying to defend my former client's position as having the case dismissed. But in the affidavit, I explained what the issues were. But you're 100% right. I should have immediately filed the corrections. Then, as opposed to just focusing on reply briefs and then working to get it done. But again, my attention was on other issues, which again is not the court's problem to deal with. The court, do you apologize? Blackburn, 100%. Court, do you apologize to opposing counsel? Blackburn, yes, I apologize to them. I am very sorry for all the confusion that I created. And for even having to come and deal with it, I should have been more careful and more clear with what I do. Honestly, there's nothing else for me today, honestly. So, I take full responsibility, and I made a lot of changes, not only to this case and beyond in this issue, the language I do, what I do. The people who the court says, I appreciate that. It cuts them off. So, okay, that's enough. Anything else before we adjourn? Post, yes, Your Honor. Part of this with regard to the fee petition, the reason fee petition, there's no protective order in this case as far as submitting invoices that may have privileged information on it. The court, I'll sign that petition order. Mr. Pulch, okay, thank you, appreciate it. The court, that goes without saying. Anything else? Okay, we're adjourned. So then they adjourn the case. All right, everybody, we have gotten through this whole transcript. What do you think? We'll sit here and wait until the judge decide whether to impose sanctions on Tyrone Blackburn or not. I personally feel that the judge is more than fair. He got on both Tyrone Blackburn and TD Jakes' attorneys for, their indiscretions and their lack of preparedness or whatever it may be. So I feel that the judge is totally fair, that whatever he rules, he will be fair in his assessment. And hopefully we can get past this and move on. Now, do you all think if this case is going to continue, or do you think that it's going to end? My assessment, my feeling is that um, Bishop T.D. Jakes is not letting this go. I believe that he is going to continue this case, whether Tyrone Blackburn is on the case or not, because that's irrelevant. Because it's relevant, but it's irrelevant because he is suing Duane Youngblood. Even though now Youngblood has new counsel, which is the Pro Hoc Vice sponsor of Tyrone Blackburn, which means their law firm is the ones that allowed Tyrone Blackburn to practice law in Pennsylvania underneath their license. But I do believe that TD Jakes is going to move forward with this case, and that he wants all those 10, at least 10 John Does named, and he's going to go full steam ahead. But that's my opinion. I need you all to get in the comment section and tell me what your opinions are. And so a lot of this is a lot of reading. Make sure you all like, share, and subscribe, and we will get back on it. Now, in a couple of days, I'll probably end up doing another video if they post the fees that TD Jakes is assessing that should be paid if the judge requires sanctions of Tyrone Blackburn. And then in another week, it will be Tyrone Blackburn's answer. And then after that will be the judge's response. Also, whether Judge Stigman is going to honor the request to take Blackburn off the case. So technically, Blackburn is still on this case because the judge has not released him, even though, like I stated earlier, the Pro Hoc Vici sponsor in Pennsylvania is representing Duane Youngblood. We'll see what happens. And if you all are still interested in this case, we'll continue to report on it. It's a lot of reading. Hopefully, maybe with new counsel, we won't get such long filings like we did with Tyrone Blackburn. I mean, when I saw he had a case, filing one time of over 200 pages, I was like, whoa, boy. But then this last one prior to this, it was 910 pages. I mean, this is just ridiculous. It's a lot of stuff. And we'll see how the response goes. If you all are really interested in hearing what's going on with this, we'll continue. But if not, we're going to not continue after this, right? Well, after this particular segment, as far as sanctions are concerned. But I do believe that TD Jakes is going to continue to move forward with this case full speed ahead. I don't believe he's playing. I believe that he's serious and he wants justice, and he wants that stain removed off his name um, by the allegations of Duane Youngblood. But anyway, everybody, thank you for joining Save News TV. We appreciate you so much. Thank you for allowing us into your homes, because you did not have to. You all have a wonderful and blessed day. Bye.
Getting bored? Want to enjoy some relaxing music? Do you need to get updated with all the latest news, but don't have enough time to watch TV for hours? Or do you need to get your praise and worship on? We have your solution to your problem. SAVEDnewsRadio.com got everything you need. Listen to SAVEDnewsRadio.com, filled with praise and worship 24/7, everywhere, in your home, laptop, or tablet, on your phone, in your car, and on Alexa. Install the Save News Radio skill on Alexa, and then just say, Alexa, launch Save News Radio. The beautiful, uplifting sounds of praise and worship music, ministries, news, and more. SaveNewsRadio.com, created to glorify God and edify the body of Christ.
I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, that's amplified. I am spreading the faith I hold so dear. For every tear he's ever near. Choirs rise on Sunday morn, his love we adorn. Each melody, a testimony, hearts reborn.